today case study has been explained and presented by Sri Kalidaha, which is very much useful for the uh, uh, common people, and which is one of the goal of NCSM to promote science popularization and IPR also to the common people. So thank you very much, Amyo Kalidaha sir. And now we have, I am welcoming Mr. Amit Kumar Patel. Mr. Amit Kumar Patel is a managing director of Patectual IP Law Services, and he is a registered patent agent and advocate of IP law practitioner. Mr. Patel is a very young, enthusiastic personality, and he is uh, working as a advocating in the domain of patent, trademark, copyright, and design, and filing the patent also. He had passionately delivered more than 400 IP expert session on various topic of intellectual property, innovation, entrepreneurship on various stages. He had successfully supported more than 700 IP generation by startups, MSME, and academic institutions. He has completed his M Pharma with a specialization in pharmaceutics from KV College, Gandhinagar 2010, and he holds PG diploma in patent law degree from Nalsar University, Hyderabad, and he has completed his LLB from Gujarat University. So I won't take much time to start the session because I think things are more important to explain. And sir will explain about how to file the patent. So thank you very much, sir. Again, to be given time for us. And it is our pleasure again to welcome you. And now, sir, this online stage is yours.
Thank you very much, Niranji, for a kind introduction and a kind invitation and giving opportunity for interacting with various stakeholders of our country, right? And it is a really good activity what National Council of Science Museum you are conducting for spreading the IP awareness in our society, which is really much required in today's time. So without waiting for next moment, let's start with the session.
And I can
Yes, sir.
Yeah, continue, sir.
Yeah, please let me know if my slide is visible to all. Okay.
It is visible.
So, yeah, we are going to discuss with the patent filing system in India. Okay. And many a thing which is already covered, right? Earlier session was really very eye-opener. And our speaker, right, Mr. Khalidaji has given a very, very interesting real-life case studies to discuss about what is IPR, what kind of mistakes, not only the normal civilians, but even the, we can say, learned people and the big corporations are making, right? And how also the different strategy to overcoming from the same. Now coming to the topic assigned to myself is the patent filing in India. So before we go and jump into the patent, this is just an overview which might already have covered. Patent is a type of IPR, intellectual property right, and this fundamentally includes all the kind of human mind creations. Whether you write a novel, whether you write a song lyrics, whether you give a music composition, whether you design a logo for a company, whether you design a product, new product, whether you develop a new technical solution of a problem. So any kind of human mind creativity, right, which is itself is an intangible asset, no physical form. So this is intellectual property right. This is an area to give a legal protection to all the kind of human mind protection. So this is IPR is a superset or the masterpiece under which there are different forms of IP, patent, trademark, copyright, design. integrated circuit, geographical indication, and trade secret. So these are the type of IPR, and each has a special purpose. The special kind of human mind creativity is protected by each type of this IP, right? So this might be covered. I suppose that this might have already been covered in detail with by any other speaker in earlier of the session. Now we will focus towards the topic which is assigned to me, patent. So first of all, try to understand its definition. What is the basics? Okay. So the definition says it is the exclusive right granted by government to inventor. Exclusive right means only to him and excluding all others. This exclusive right to inventor by the government. And what kind of rights are given? For the manufacturing, use, distribution, and sell. These, suppose if you have a patent, it means that you have exclusive rights for this operation, manufacturing, using, distribution, and selling for a limited period of time, that is 20 years. Okay, so this is legal definition. And fundamental, look, what kind of human mind creativity is protected by a patent? So this protects any kind of technical advancement with respect to product and processes. So anything you see around yourself in the world that can be either a product or process. Nothing else can be possible beyond these two. So with your intellectuality, creativity, if you create a brand new product, brand new process, they are patentable. Or even if you make even a very small change into existing product and process, okay, very small change, right? And if that change is with respect to patentability requirement, if those criteria are met, that part of change is also patentable. So this is fundamental, right? Definition and what you can protect as a patent. Now, what are the criteria of patentability? So these are the common criteria worldwide, and these are the common criteria for all the kind of invention from any technical field. No differentiation for medical science, no differentiation for chemical industry, no differentiation for the electronics. All the invention from all technical domains, they are judged on these three criteria only, right? And worldwide, they are the common. So if your invention, either a bigger or the smaller, if that invention satisfies these criteria, each person is eligible to go for patenting. Right? For applying for a patent, there is no minimum requirement like a minimum age or minimum education qualification. Okay, so even a standard 5 kid or even a very elder person of 70-year-old, even a PhD scientist or an illiterate mechanic, any person, whoever creates anything from their mind, and if that creation satisfies these three criteria, they are eligible to apply for patent. So first is the novelty. Whether their invention is completely new in this entire world, that is to be checked. Non-obvious. So whether that invention is obvious or something different. It shouldn't be very general or common to every person in the field to be think of, right? It should clearly represent your technical mind involvement. And next is the usefulness. It should be useful to any individual, society, or industry. So if the answer for these questions are positive, any person from any background, literate, illiterate, of any age, they can go for patenting. Now, type of patent application. So when you go and apply for patent application, there are multiple type of applications. First is the ordinary application, either a provisional or a complete. Provisional or a complete. So if you create something and if you apply for a patent into India, so that patent can be applied as a provisional or a complete. If full details are not disclosed, you can apply as a provisional. If full details are ready, you can apply as a complete. Right? If you from provisional to complete, there is a window of 12 months. Within 12 months, you have to must file the complete. right? Anyone can go and apply complete application directly as well. That is also possible. Next is convention application. So from India, right? IP rights are territorial in the nature, means country specific. So whatever you create in whichever country you need your exclusivity, you need to go and have a patent right in those countries. If you will not file in those countries, then you will not have exclusivity in those countries. So suppose if you are interested to have a patent in China, only in China, then you can directly file India and in the China. So that your Chinese application would be regarded as convention application. Now, if you are targeting that I want to have a patent protection in more than 10 countries, right? So in those scenarios, you can file a local application, then file a PCT application within a period of 12 months from the first file date, right? That PCT application, PCT international application. So that is this one, PCT international application. Then PCT national phase application. So via this PCT application, your national phase entry period would be extended from up to 30 or 31 months, right? And after that 30 or 31 months, when you go and make the application in individual countries, those individual applications would be regarded as PCT national phase application. Application for patent of addition. So if you are working on continuous improvement projects, long-term scientific projects, so however, whatever you are creating, those parts you can protecting in the part of additions. Basic application, then the further patent of addition, patent of addition, patent of addition. Divisional application is the one when, right, patent has a concept like one patent, one invention only. So if you have merged more than one invention in one patent, then you require to bifurcate and divide that. So when you from basic application to dividing in multiple application, so those next dividation application would be regarded as the divisional applications. Now these are important, right? Don'ts to get a patent. Don'ts to get a patent, and these are the biggest mistakes what we these are normally seen, the maximum mistakes what Indians are making, whether they are the academic players or whether they are the industry players. So if you have created something and want to apply for patent, what shouldn't be done? Okay, so stay away from publication, any kind of publication, research paper, internet, newspaper or poster present. Before you make the patent application, the first you should make a patent application, and before that patent application, you shouldn't do any of this. Once the patent is filed, you are free to do any of this. But before filing the patent application, not to do any of this. And if you will do any of this, your novelty will be gone. And once the novelty is gone, patentability will also be gone. So stay away from any kind of publication. Stay away from taking part into any award competitions before filing the patent, event, workshop, seminar, conferences. Stay away from any kind of public display of your invention, either a fair, public place, YouTube, Facebook, website or social media. So many people are taking a photograph, video of their invention, take a video and upload in any of the social media. So that will also be a complete disclosure of invention. That will kill the novelty. And then patentability is gone. Stay away from any kind of production or the marketing of the product. So before you file the patent application of your invention, you should be stay away from any of these. If you will do any of this, that will kill the novelty. And once the novelty is gone, patentability is gone. So be very careful. Now, it is usually seen in Indian scenario that if we create something, we go for the research paper filing. We give more importance to publish research paper than going for a patent. So what would be the scenario or the differences? There is one thing you have invented and you have two options, either go for the first research paper publication or first as a patent publication. What is the difference between two? Look, So research paper, first of all, gives you no ownership, whereas patent gives you the ownership for the or the exclusivity for manufacture, use, distribution, and sell. So first difference is the ownership. Second is when you go for the research paper publication, they doesn't give you ownership, but they are also taking away your copyright ownership. You need to assign copyright to the publisher. Whereas in terms of patent, ownership will always remain with you. For research paper publication, there is a no compulsory criteria like novelty, non-obviousness, usefulness. So the same thing you can go and submit to different journals, they will readily accept and publish it. Whereas for patent, novelty is the must. So even though if you will submit the repetitive work, those will not be get it granted. Next is based on research paper, as it is not giving any ownership. If any other person is practicing the same thing what is written in it, you cannot stop them legally, because you do not have any ownership. Whereas if you have filed a patent, and if based on that the same invention any other person is doing or copying the same, you can take a legal action against them and you can stop them. First filing a research paper and then filing a patent, it is not possible. Whereas first filing a patent and then filing a research paper is always possible. So these would be the major differences between what to go for first filing. Now look at India's patent filing is just nearly 15,000 patent in a year. And of that, India's contribution is lesser than 17,000. 17,000, right? Whereas in the same 1 year time period, the world leader is China, who is filing nearly 15 lakh patent. 15 lakh, whereas India only 50,000, and Indian's contribution is just 17,000. So why it is a huge difference? So the biggest reason for this is the lack of awareness, right? And that's why look at this. We are carrying out many important aspects, and 1 minute. Okay, sorry for disturbance. Yeah, so whereas look at India's research paper publication number is very high. You were able to see that nearly 4 lakh research papers are being published in 1 year by Indians. So of these, many of these are possible to be applied as a patent. So change your perspective. That doesn't think that patent means only for the rocket science, only for the biggest researcher or the scientist or PhD holder, or only for the guys who are studying in IIT, NIT, AIMS, or very reputed institutes. They are only able to do it. Every Indian citizen, right, with their brain, if they observe something, they have idea. If they transform their idea into the product, and if that product is novel, non-obvious, useful, anyone is eligible to go for patent, either for bigger invention or very small invention, right? So with this, if now you understand what can be patented, so where now if you want to go for patenting, the journey starts from here. Patent search. So first of all, you have to carry out the patent search or the prior art search, wherein you have to define novelty, whether what you have carried out, it is completely new or not. If it is reported in any part of the world, China, USA, Germany, Japan, Korea, then your invention is not new, it is not patentable. So via carrying out the patent search or a prior art search, you be assured that your invention is novel. And this includes searching into the patent, research paper, journals, YouTube videos, social media, newspapers, trade show brochures, anywhere. Everywhere you have to carry out the search. Okay, and it is never ending task, right? Now, to carry out the search, there are different search formats: novelty search, validity, infringement, clearance search, freedom to operate, state of the art, landscape search. But the presently, to prove, right, these are the type of search based on the objective, what you need as a result of that search, right? What is your objective? Based on it is regarded as a different type of IP. So our present interest is the novelty search, to prove that whatever you have developed, it is nowhere reported in any form across the world. That is novelty search. So this search you are carrying out via using different resources. Research paper databases, yes. And apart from that, you can also require to search the patent databases. So this includes number of free patent databases: US patent database, EPO database, patent scope database, Indian patent office, Google patent, free patent online, big patent, and there are number of others, right? If you will simply search for free patent search database on Google, that itself will give you a very big list. Apart from this, there are a number of paid databases as well, which comes up with a special developed features to assist your search in a better way, right? But for this, you require to subscribe and pay the fees. So these are the number of paid databases. Now, after searching, next comes is the drafting, right? So when you are confident that, yes, my invention is novel. So how you will start? You will start with the drafting. You have to prepare the documents, patent drafting. So before patent drafting, you have to be clear with these questions. What is the invention, right? So when you have developed a prototype, do not intend or do not represent like, I need a patent on this entire prototype, right? So many of that prototype or product are already known. You just integrated already known components, right? So first of all, identify out of entire prototype, what are the things which you have intellectually developed. Those would be your patentable subject matter. So identify the invention and then check whether they are patentable or not within the Indian context, right? Then is the invention novel and inventive, right? That is to be judged. If answers are true, then you have to carry out the prior art disclosure search, whether you have made in any disclosure or not. Now, drafting is regarded as the art. The more you will practice, more it will get improvised. Okay, so before drafting or preparing the document, you should be ready with this different part of patent document. You have to decide what would be the title of your invention, brief description of invention, and detailed description, right? So here you have to define what are the different components, what would be their role, how they are interconnected, how the entire invention is going to be worked, what would be the different control parameters, what would be the different range, right? So all these in the detailed manner along with the drawings you have to prepare and get prepared for the patent drafting. Then you have to define the claims, right? What is your invention, what you have developed, right? And what would be its technical characteristic, not the objective, right? What would be temperature range, what would be pressure range, what would be the dimension or the scope range, that you have to define, and these will be your rights, ownership right, claims. Then a small abstract of figures. You have to define the inventor and the applicant, right? Who will be inventor, who will be the applicant. Then you have, for patent filing, you need to prepare these documents different. Like for passport, we have to fill the form. For Aadhaar card, we have to fill the form. Likewise, if you want a patent, you have to fill this set of forms. Form 1 is the application for patent. Form 2 is the technical details of the patent, which includes title, field of invention, background of invention, objectives of invention, what is the principal invention, general statement of actual invention, detailed description, claims, abstract, and the figures, right? Then statement and undertaking regarding foreign filing, whether you have filed in any other country or not. Declaration as inventorship. You are the first inventor, that you have to declare. Request for early publication if you want to publish early. Then request for examination. and the form of authorization, right? If you are getting or filing through any professionals. Now you can file in the online mode, in the offline mode. If you want to apply in the offline mode, you have to prepare the document and need to submit into the patent office physically, or you can send them via registered speed post or the registered AD, only via Indian Post, no couriers. You can also file them via e-filing route. Okay, there are it is started since 2007, right? Patent agent, professional or inventor, they can file. The different benefits, like you can apply online anytime, real time you can make a payment, real time you will get the receipt. These are different benefits, right? So these are the different steps. You have to procure the digital signature, you have to create your account, right? You have to fill different forms, you have to upload those documents, right? You have to digitally sign them, right? And you have to submit along with the fee payment, right? And at the end the acknowledgement receipt will be generated. So the digital signature from any of these approved vendor, TCS and Code Solutions, subscript, they are valid for patent filing. Either class 3, yeah, presently class 3 digital signature is valid. Earlier class 2 and 3 both were valid, now only class 3. Now patent prosecution. So the documents are ready. Now patent filing itself is a very multi-step and lengthy procedure. Okay. So look, there are different stages you have to go through. First, you have to make the application either a provisional or complete. So that if you file a provisional, within 12 months, you have to file complete. After that, next would be its publication, right? This publication will be happen in the official patent office journal. At the end of 18 months, if you haven't requested for early publication. If you have filed the early publication request, it will publish within 1 month. Next is the examination, right? So whatever we submit, patent office also gets it examined, and they will give you the examination report. With that report, you have to submit the reply for examination report. And if after that reply as well, if there are any unanswered question, you have to appear for the hearing. And when you satisfy on all their requirements, at the end, the patent office will grant your patent. And once it is granted, you require to keep it renewed for 20 years, every year renewal fees. Okay, the same procedure what I described in earlier route. This is the same layout, right? 20 years time cycle in one slide. So you apply as a provisional or you apply as a complete. If you apply provisional, within 12 months you have to file complete. After complete, next is a publication. Without fee, after the end of 18 months, if you pay the additional fee, make a request for early publication within 1 month. After publication, there will be the examination by patent office and they will give you the first examination report. You have to make its reply. If there are still any unanswered question, there would be a hearing, and on satisfying all the requirement, they will grant it. And once it is granted, you have to pay the renewal fee on every year till a period of 20 years. And after that, it will get expired and open for the society. Now, these forms and fees. So these are different forms, what we said, like form 1, 2, 3, 5, 9, 18, 26. And this is the government fee. Government, for patent, there is a 2 fee, government fee and the professional fee. So here is the government fee. Now that fee is based on the type of applicant. If you are natural person, startup or a small entity, your government fee would be 8,100. But if you are applying as a legal entity, your government fee will be 5 times higher for the same patent, the same kind of right? And once the patent is granted, it requires a renewal on every year basis. So third, fourth, fifth, sixth, every year you have to pay 800. 7, 8, 9, 10, every year 2,400. So for natural person to maintain their patent for 20 years, it will require a government fee of 76,000. For legal entity, 5 times higher, nearly 3,84,000. This is government fee, and the professional fee would be like which expert you approach, what is his background, what is his expertise, right? and based on that they might charges a fee from 50,000 to, there are a very solid and the experienced professional who charges up to 2 lakh rupees as well for the same patent. So it varies from professional to professional. Now, patent cooperation treaty. So if you want a patent protection in multiple countries, India and multiple countries, you have a two route, right? Today you file in India and within 12 months you have to file into the respective countries. This is a normal traditional route, conventional route. Now, and here within 12 months, you have to select the countries, you have to file all the document, you have to pay the government fee, you have to pay the professional fee. Okay, all the details within 12 months. So now, if you have a multiple countries target, right? The advisable system in today's time is a PCT route, wherein all your time requirement for submitting document to this country will be extended from 12 months to up to 30 or 31 months, right? So the time will be also extended and all your investment on the 12 month will be also extended up to 30 months. And within this timeline, you will have a multiple supportive documents available. International search report, international preliminary opinion on your patentability, right? And if you apply for expedited route in India, so within 12 months, you have a guaranteed, right? Great satisfaction whether your invention is actually patentable or not. So based on all this, you can make a strategic decision whether you are ready, your invention is capable enough to get prosecuted in all those countries and getting it granted. If answer is yes, you can go and invest over here. Because if your patent will not be granted for any of the reasons, there wouldn't be any refund with respect to a government fee or a professional fee, and it would be a huge cost, right? So that's why you should have a strategic decision, and that you can make over a period of time with all these supportive documents. With this, I would just like to conclude my presentation over here. If you have any questions, you can ask right away, or you can always write an email or give me a call. Thank you very much to everyone.
Thank you very much. And one question is coming from our YouTube viewers. Sir,
Yes,
the
sir.
two person, Mr. Prabhunath Singh asking, two persons applied for same production for patent. Their process are different, then both will get the priority right. Property
Yes,
right.
very true, right? So here is the very important question, right? Whether first, look, first you have to understand the end product is available in the market on the present day or not. If end product is not available, okay, now if both person has a different process, then both are eligible to get it patented. If those processes are satisfying the novelty, non-obviousness, and the patentability criteria. Okay.
Okay.
And now for the product itself, if the product is novel, right, and both are applying for the same, who will get the product rights? So for that, we have a mechanism like first to file. So whoever has made the first patent application, that fellow will get the patent rights on the product, right? But for process patent, both are eligible.
Okay, thank you very much for giving the answer, and hope this session will help us to understand the patent process and filing the process. And Mr. Patel told about the China is filing some 15 lakhs patent per year, and India is very much lagging behind. Hope the session will help to enhance the patent numbers. Even our universities is publishing more than 4 lakhs research paper throughout the year, and there may be a scope to convert that in the patent form. So more and more such kind of awareness from the school to college also required, I hope. And Digha Science Center and National Council of Science Museum will try to propagate this message and in the form of presentation, talks, and various forms in the workshop to the common people, common person. It is just like, I hope it is just like the share market. No need of education. Anyone can enter.
True.
So it is patent also is like that. Ki anyone can file the patent.
Very true. Every
Uh,
person has a brain, right? And with that brain, every person has a capability to think and create, right?
yes, sir.
But we are just a lack of awareness that whether these creations are also patentable or not.
Yes, 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 yes. So thank you very much, Mr. Patel. On behalf of entire Digha Science Center and National Council of Science Museum, I am just expressing my gratitude and heartful thanks
Thank you. Thank you,
for
sir.
your presentation and giving the time in your busy schedule. And hope your continuous support with our organization will continue. Thank
Yes.
you.
It would
Thank
always
you.
be our pleasure to be associated and support in any kind of IP awareness or IP protection activities. Always, sir.
Oh,
Thank
thank
you.
you